So premise liability cases are, they're a little different than negligence cases. You have to show foreseeability that there was a danger out there. And so, for instance, if you went to a store and there was the famous, most famous example of this is the rotten banana peel case. And so there was a store and there was a banana peel and a customer slipped on it and they fell. And they badly injured themselves. Well, what did they do? Well, they had to show notice. So foreseeability and notice. So once you know that there is a danger out there, the slippery banana peel, did they immediately go pick it up or did they not? Well, the banana peel was black and brown, and so it had been sitting there a while. And so that element turned on the fact that the banana peel had just so heavily decayed that it must have been there for, a day or two. And so the facility or the store had notice. They appreciated the condition because they had employees walking up and down the aisle. They left it there. They didn't remedy it. And so that created a burden. Once that risk is there and you open your business to a public person like that, well, then you need to have it be safe for them. And so the reasonably prudent thing to do would be to clean that mess up and make sure nobody slips on it. And that's why you see the wet floor signs. That's exactly why they're there. Because you don't want to have a wet floor and somebody slip on it. Because you know it's wet, and that means you should be taking care to either warn people to make sure they know not to slip on it and step over there, or to remedy it to make it safe. And so that's where the obligation is created. Once the obligation is created, once that person has slipped on it and they didn't make it safe, that they violated that obligation. And so the next element that you look at is causation. And so did that fall actually cause the injury? And so that's corroborated through medical records, testimony, experts, and the like. And so that is just one example, but there are many examples of premise liability, including negligent security. There are strict liability premise cases that involve dangerous conditions on the premises. There are actively dangerous conditions that can constitute a little difference than a premise liability case. And so it's important to have a lawyer if you think you've suffered an injury on a premise location or a business or a work, to review that to understand what elements might apply and what conditions were there, so you can understand the legal burden, because it changes depending on the facts, depending on who's going in. Was it open to the public? Was it a trespasser? Was it someone who's an invitee? And these are all legal terms that your lawyer needs to ferret out. And so if you have questions about that, give us a call.